Test yourself with 15 real estate contract traps that keep showing up on licensing exams. We will move through formation, contract types, and breach or enforceability trap. If contract questions keep tricking you, this will show you exactly where the logic breaks. Block 1. Formation essentielle. Valid contract requirements. Writing rules, consideration, binding. Question 1. Which of the following is required for a valid contract in California? Your choices are A. A witness signature. B. Notarization. C. Mutual. Pause here. Take 4 seconds and choose your answer. The correct answer is C. Mutual consent. Explanation. A valid contract requires competent parties, mutual consent, offer, and acceptance. Common trap. Students often default to formalities like notarization or recording in. Question 2. The statute of frauds requires that. Your choices are A. All contracts must be notarized. B. Real estate contracts must be in writing. Pause here. Take 4 seconds and choose your answer. The correct answer is B. Real estate contracts must be in writing to be enforceable. Explanation. The statute of frauds requires certain contracts, including those for the sale of real property, to be in. Common trap. The exam likes to test whether you know writing is about enforceability, not. Question 3. What constitutes consideration in a real estate contract? Your choices are A. Money only. B. Work only. C. A promise only. D. Pause here. Take 4 seconds and choose your answer. The correct answer is D. Money, work, or a promise. Explanation. Consideration can be money, services, goods, or a promise. Anything of value exchange. Common trap. Students make consideration too narrow and think only cash count. Question 4. A purchase offer becomes a binding contract when signed by. Your choices are A. Buyer only. B. Seller only. C. Seller and agent. Pause here. Take 4 seconds and choose your answer. The correct answer is D. Buyer and seller. Explanation. A purchase offer becomes a binding contract when both the buyer and seller have signed, creating. Common trap. One signature is not enough. The contract binds when both sides have. Question 5. A seller rejecting an offer, changing terms, and resubmitting creates. Your choices are A. Counteroffer. B. Altercation. C. Offer. D. Pause here. Take 4 seconds and choose your answer. The correct answer is A. Counteroffer. Explanation. A counteroffer is a rejection of the original offer combined with a new offer on different terms. Common trap. Changing terms is not a harmless edit. It kills the original offer. Block 1 recap. If this block fell hard, the usual fix is simple. Know what creates enforceability, what ends the original. Block 2. Contract types and conditions. Bilateral contracts, options, lease option traps, contingencies. Question 6. A bilateral contract is one in which. Your choices are A. Only one party makes a promise. B. Both parties make promises to each other. Pause here. Take 4 seconds and choose your answer. The correct answer is B. Both parties make promises to each other. Explanation. In a bilateral contract, both parties exchange promises. A sales contract is bilateral because the common trap. Students hear contract and think writing requirement instead of promise. Question 7. An option contract in Michigan gives the buyer. Your choices are A. Ownership of the property. B. The right, but not obligation, to pause here. Take 4 seconds and choose your answer. The correct answer is B. The right, but not obligation, to purchase. Explanation. An option contract gives the buyer the right, but not the obligation, to purchase the property within a specified. Common trap. An option does not transfer ownership. It only gives the right to buy. Question 8. The difference between a lease option and lease purchase is. Your choices are A. Lease option obligates seller only. B. Lease option obligates. Pause here. Take 4 seconds and choose your answer. The correct answer is A. Lease option obligates seller only. Explanation. In a lease option, the seller is obligated to sell if the buyer exercises the option, but the buyer, common trap. Both sound like rent to own, but the buyer is not equally bound in both. Question 9. Contracts with contingency clauses are. Your choices are A, voidable, B, valid, C, void, D, execute. Pause here. Take 4 seconds and choose your answer. The correct answer is A, voidable. Explanation. Contracts with contingencies are voidable because either party may void the contract if the contingency is common trap. Students treat contingencies like automatic void contracts when they're. Question 10. A Missouri land installment contract for deed. Your choices are A, is prohibited, B, is regulated with buyer protections. Pause here. Take 4 seconds and choose your answer. The correct answer is B, is regulated with buyer protections. Explanation. Missouri regulates land installment contracts to provide protections for buyers. Common trap. Installment contracts are not the same as immediate title transfer. Block 2 recap. The trap in this block is obligation. Ask who is actually bound. What happens if a condition fails? Block 3. Breach and enforceability. Specific performance. Death after acceptance. As is clauses. Question 11. A court remedy compelling a party to complete a property sale is. Your choices are A, execution, B, settling debt, C, specific. Pause here. Take 4 seconds and choose your answer. The correct answer is C, specific performance. Explanation. Specific performance is a court order requiring a party to fulfill their contractual obligations. Common trap. Because real estate is unique, contract remedies are not just about money. Question 12. The seller dies after an offer to purchase their property has been accepted. Your choices are A, the offer is voidable. B, the grandchild is compelled to sell under the terms of the. Pause here. Take 4 seconds and choose your answer. The correct answer is B. The grandchild is compelled to sell under the terms of the. Explanation. An accepted offer creates a binding contract that survives the death of either party. Common trap. Students think death automatically destroys the deal. That is true for off. Question 13. An as-is clause in a general purchase contract. Your choices are A, applies only to matters of record. B, applies only to things that have been proper. Pause here. Take 4 seconds and choose your answer. The correct answer is B, applies only to things that have been properly disclosed. Explanation. An as-is clause transfers property without warranty of condition, but does not eliminate disclosure duty. Common trap. As-is does not erase disclosure duties or magically wipe out known. Question 14. A contract signed by a minor is. Your choices are A, invalid, B, valid, C, voidable, D, void. Pause here. Take 4 seconds and choose your answer. The correct answer is C, voidable. Explanation. Contracts signed by minors are voidable, meaning the minor can choose to void the contract or ratify it. Common trap. Minors do not always create totally void contracts. The exam wants. Question 15. An offer to purchase real estate is terminated by all of the following except. Your choices are A, death of the offeror, B, counteroffer by the offeree, C. Pause here. Take 4 seconds and choose your answer. The correct answer is C, inquiry about terms by the offeree. Explanation. An inquiry about terms does not terminate an offer. However, death of the offeror, a counteroffer, common trap. An inquiry about terms feels like a rejection, but it is not the same. Block 3 recap. These misses usually come from confusing what sounds final with what the law actually allows. Slow down. If you want more time practice and weak area review, keep going with the state pass.